Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're discussing the growing trend of a relationship structure called polyamory. Polyamory is also sometimes called ethical non-monogamy, and it's when an individual has multiple romantic or sexual partners at the same time with the consent of all people involved. The Vanier Institute of the Family recently released a report noting the rise in diverse relationship structures and family structures, including polyamorous families. Now, while data on the number of polyamorous families is sparse, a 2019 study from the Journal of Sex Research found that 1 in 5 Canadians has practiced consensual non-monogamy, and a 2023 Pew Research study found that 33% of Americans believe open marriages are acceptable. But how does polyamory interact with family law? What happens when children are involved, employment benefits, or pensions? The law assumes only two people are in a relationship. So how does this impact people living in polyamorous relationships? Here today to discuss this are two family law experts, John Paul Boyd and Michelle Kinney. Thank you both so much for joining me today. Now, Michelle, I described polyamory. I think one of the things a lot of people, including the producers in the show, have asked since I told them we were doing this episode. I mean, I gave the explanation, but people are still confused. I mean, what exactly does it mean? Is it, 3 people? Could it be 4 more? Do they all live together? What can you tell us about what a polyamorous relationship structure actually looks like?
Oh, well, I think it can look like a lot of things. I would say it's a consensual, intimate relationship or personal relationship between more than 2 people. I think the structures can be as varied as we can imagine. Some people all live together. Some people have a nesting partner and maybe another partner who doesn't live with them. Some people might have a few partners. I think there is no one structure. I think what polyamory is about consent and honesty and respect between the partners.
So John Paul, I said in the beginning there's a sort of a lack of data about how common it is, other than we seem to know that it is on the rise. Is there anything you want to say about that?
That's about all we know. The problem is that where we get our social information from, Statistics Canada is happily tracking people who get married because you have to apply to that, and then through the CRA they can track how many people are in unmarried long-term relationships. But there's no box to tick on any of the surveys, any of the forms, or on the Canada Census that says I'm in a polyamorous relationship. So we really don't know. But from some research that was conducted by the Canadian Research Institute for Law and the Family in 2017, we know that people who identify as polyamorous agree that the number of such people are dramatically on the rise, as is the number of people who are living openly in polyamorous relationships.
So, Michelle, a lot of people are probably familiar with polygamy, which is marriage to multiple people. And it's typically, most of the time when we think about it, it's often grounded in a religious practice. It's also illegal. So how is polyamory different? And in particular, I'm interested, I know a lot of the stories about polygamous marriages often involve sexual exploitation, often of young women or even girls. So how would should we differentiate polyamory, and why, and how would we differentiate it?
Well, it is different. As we were saying earlier, polyamory it's about consent. It's about having consensual, meaningful relationships with more than one partner. Polygamy tends to be more, the way we usually think of it, more often one man married to a number of women. There's shows about there's there's quite a lot of stigma around that. Polyamory, I think, is it's I would say it's not inherently more exploitive than any other type of relationship, and with the key being consensual.
Now, we've got to go to commercial break now, but when we come back, I want to talk about some of the real legal hurdles that can be involved when people are in sort of non-traditional relationship structures, whether those hurdles are access to employment insurance benefits, wills and estate planning, and what happens when a polyamorous relationship comes apart? What happens with matrimonial home or division of property or spousal or child support? When we come back from this break, we're going to discuss all of those issues. Welcome back to Canadian Justice, where we're discussing polyamory and family law. Now, in the last segment, we were briefly talking about the difference between polyamory and polygamy. John Paul, is there anything you wanted to add on what people should know about the difference and if there is a difference?
Well, I mean, Michelle summarized it quite correctly. The reality about polygamy is that that kind of relationship structure is not uncommon across the globe. Typically, these relationships are required by social norms or required by religious practice. So, in Canada, in the late 1880s, when the prohibitions on polygamy came into effect, it was a direct reaction to the expansion of the Church of Jesus Christ of Latter-day Saints, which held, a doctrine called celestial marriage, in which multiple marriages were a requirement of the religion. And then, we saw that really, come to a head in the early part of this millennium when the BC Supreme Court heard a case involving the practice of polygamy being carried out by the fundamentalist church in Bountiful. And one of the issues that were directly identified in that was indeed the exploitation of very young women, some of whom were girls, being married to much older men, the patriarchs of that community. But polyamory is none of those things. It's adults who make a free and informed choice to enter into a relationship being fully informed of the parameters of it. Those are relationships which you can choose to leave. They're certainly not compulsory. They're something that is really about a relationship orientation of the individual more than a requirement of society or religion.
So this is obviously a non-traditional religious structure, and people who want to have a family that's a polyamorous family are faced with different legal challenges than a man and his wife or even common law spouses might be faced with. So let's talk about some of those challenges. Michelle, let's talk about just the basics of filing tax returns. If you're three people in a relationship, my husband and I, we file a joint return. Many people in marriages do, but what if you're in a polyamorous relationship? How does the CRA look at that?
Well, I actually don't have an answer to that. I did ask my accountant this question, and she said, "Well, that is a really good thing that I'd like to think through," but nothing like that has crossed my desk yet. So I think this is something that the CRA is going to have to grapple with, and probably is in some ways right now.
And John Paul, what about insurance benefits? When you have insurance through your employer, typically you can add your spouse or your partner as onto your insurance plan for dental care, for prescription drugs. What about your polyamorous partner? If you're in a multiple person relationship, I assume you cannot add an additional partner. Do you think that it makes sense to limit it to just one person? Otherwise, our insurance premiums would be impacted, or do you think that the insurance industry needs to adapt?
Well, the reason why we're having this discussion at all is really about the fact that all of the laws in Canada and in all of its provinces and territories, are written on the implicit assumption that important long-term adult relationships only come in pairs of people. And that's where we start hitting all these walls. The legislation on wills and estates talks about your spouse in the singular. It doesn't contemplate that you might have more than one person who might qualify as a spouse. As far as insurance programs are concerned, well, it's really only until the last couple of decades that people who identify as polyamorous have begun being open about their relationships. So quite understandably, the average insurance company, whether it's a public company or a private company, thinks about important adult relationships as only coming in pairs. So you as the employee get extended health and dental benefits. Well, who is your spouse that you're going to nominate as a beneficiary? So the problem you have there is that from the insurance company's point of view, it's a pair, it's a pair, it's a pair, and it's nothing else. And so if you're in a polyamorous relationship, you may face the incredible decision of having to decide which of your partners you're going to identify as your spouse for the purposes of insurance. And that's a horrible choice to make. But as polyamorous family structures increase in popularity, like Michelle said at the CRA, this is something else that insurance companies are going to wind up having to grapple with.
Although I suppose someone could take out an additional policy to ensure that their person is insured. So
Yep.
I do think if you live your life in an unconventional way, you might have to come up with unconventional solutions. We've got to go back to commercial, but we will be right back. Welcome back to Canadian Justice, where we're discussing polyamorous relationships and family law. Now, Michelle, I have a question about how family law might treat people in polyamorous relationships through, wills and estates or choices around end-of-life care. What advice do you have for people in polyamorous relationships who want to plan for the inevitability of one person in the relationship passing? Is it just a matter of ensuring that you do have a will, which is something people in any relationship indeed should actually have in place?
Well, I think that it would be prudent that polyamorous families should be actively contracting out of the defaults in the law, probably wherever possible, to ensure that they have the arrangements in place that would address their family needs and family structure. So like cohabitation agreements, or sometimes called prenup agreements, to deal with property and support obligations under the family laws, representation agreement for healthcare decisions, defining who can make those decisions for you, and wills for if one person dies. If they don't have these, then they're subject to the defaults in the law, which will not likely reflect their reality well.
Yeah, the defaults in the law tend to assume, as we've just been discussing, a relationship between two people. Now, that's especially true when it comes to separation and even divorce. So, John Paul, what should people in polyamorous relationships know about, if a relationship ends? Is there any obligation if two people in a polyamorous relationship are married and there's a third partner, if one of those people wants to leave the relationship, is there any obligation at all in the default law to help provide any type of support for that third person? Or should they enter some type of contractual arrangement related to cohabitation or another different type of contract?
Well, so the rights and obligations that arise when a family separates are all based on the nature of the relationship between the people who are separating. And, some people are just parents and they've never lived together. So parents have rights about, parenting time, decision making for kids, and things like that. People who are in long-term unmarried relationships might be a spouse in some provinces. In other provinces, they might be an adult interdependent partner, and in others, they might be a common law spouse. And then, of course, people who actually marry each other are married spouses, and they have certain rights. So it changes from province to province. And so the issues that arise when a couple separates or when a family separates or just one person leaves a polyamorous relationship all depend on how the nature of that relationship fits within the definitions under the law of the particular province. So in British Columbia, for example, unmarried people are spouses just the same way as married people are, as long as they've lived together for at least 2 years, right? And in British Columbia, through a quirk in the legislation, you can have multiple spouses at one time. But in other provinces like Alberta, there's a strict cap. You can only have one spouse and only one adult interdependent partner, and you can't have an interdependent partner while having a spouse. So it all depends on how the law works in the particular province. But what families are going to run into is, again, that fundamental assumption that relationships come in pairs. So the British Columbia Family Law Act, for example, has language that talks about both spouses are entitled to a one-half interest in family property. Right? So that language is clearly unfriendly to polyamorous individuals. So ultimately, the solution is what Michelle said just a few minutes ago. It's about cohabitation agreements, because the people who are entering into these kind of sometimes very serious relationships have to contemplate and anticipate what are the legal issues going to be in the event that one or more of us leaves our relationship? How are we going to divide up that property? And the last thing they want to do is to wind up dealing with that stuff in court, because the court is singularly ill-equipped to apply laws designed around two people to a family that involves 3, 4, 5, or however many adults it might be. So it's about cohabitation agreements, and it's about talking in advance about go ahead.
Yeah, I actually think that's a really interesting point about courts not being equipped when the assumption is two parents, because there's actually two cases related to child support or identifying the parents when it's a three-person relationship. There's cases from both Newfoundland and British Columbia where the courts were addressing a law that just does not contemplate this. So when we come back from the commercial break, we're going to talk about those two cases. Welcome back to Canadian Justice, where we are discussing polyamorous relationships and family law. And I think one of the complicating factors in polyamorous family law structures is perhaps when children are involved. And I know that there are cases in Newfoundland, Michelle, and also in British Columbia, where the courts have actually recognized more than two parents. They've recognized three parents in these cases when it involved people in families who were polyamorous. So what can you tell me, Michelle, about those cases in Newfoundland and in BC?
Well, there's a really interesting thing happening where I think, and I think it really started happening with the BC Family Law Act in 2013, which changed the scheme about how you can determine who a parent is in assisted reproduction situations. And so it actually allowed for there to be three parents, four legal parents in certain situations where assisted reproduction is used and where agreements are in place. And the intention behind that was to ensure that putting the best interests of the children first, creating stable families, and supporting those families. So I think we're now seeing a similar evolution with respect to polyamorous families, because we already know across Canada, starting with BC and then Ontario and then Saskatchewan, and then the legislation determining who a legal parent is was deemed unconstitutional in Manitoba. And there's a wave going across Canada with respect to who is a parent. And while it's restricted currently to assisted reproduction situations, it lends itself to polyamorous families. So yes, there are two cases now. And the second one was the British Columbia case, which followed the Newfoundland case. And in Newfoundland, it was a landmark decision that allowed three adults in a polyamorous relationship to become all three legal parents to their young daughter. Even though it was not an assisted reproduction situation, which has started to be carved out. And then in BC, a more recent case, again, three adults applied to be all legal parents of their child, and they petitioned to the court. And during those discussions, there was a debate about whether these structures could apply in situations where it's not assisted reproduction. And the court deemed that it was appropriate and looked back and thought that the legislature, when making the Family Law Act, didn't provide didn't turn their mind to polyamorous situations. They addressed the concepts within assisted reproduction situations, but not in sexual intercourse situations. So I think
So
it's
that's a
changing as the society evolves.
So that's a really interesting point to me, this idea that the legislature hadn't contemplated that. Because in these cases, the BC case and in the Newfoundland case in particular, it was the courts that recognized this third parent. It was not recognized because, in particular, Newfoundland, because of legislation. And to some degree, this seems like a policy choice by our legislatures to recognize, maybe IVF parents, but not parents in polyamorous relationships, and that they might have a policy preference for two-person relationships. So is it the role of the court to recognize alternatives when it wasn't something that the legislature considered, or maybe the legislature might not want that? Or is that perhaps the court overstepping? John Paul?
Well, I mean, it's hard to blame the legislature for the way the legislation currently is. Remember that this relationship structure only made headlines just a couple of decades ago, and we're dealing with legislation that has a historic span of hundreds of years. So, it was not on the social radar. That's reflected in the legislation, and it is why we have what we have. And governments are capable of amending the legislation to reflect those changes if they think it's appropriate to do so. But one of the role of the courts is certainly to step in the event that the governments are failing to react as quickly as society needs.
That's all the time we have. It's such an interesting conversation. John Paul, Michelle, thank you so much.
Thank you for having us.
Thank you.
We've heard today about the rise in polyamorous relationships and the legal challenge that people in this unconventional relationship structure may be faced with. Do you think the law needs to change and adapt, or do you think it's best to keep things as they are? You be the judge. I'm Christine, and remember, a freer Canada starts with you.